debt recovery in EU law and from the perspective of Slovakia. You can certainly stand up.
Ladies and gentlemen, my name is Miroslav Slastan, and I am from Slovakia. My core job, full-time business is teaching at the Faculty of Law at the Commonwealth University, but also my part-time business is forum shopping. It means, is it okay with the code of conduct, practical academy, to introduce a little devil?
Of course.
In my presentation.
We're all little devils here.
I'm so sorry. I know that I'm the last barrier between this building and the next building, where reception is already prepared. So I'm trying to be effective. So my part-time business is to find for clients the most proper jurisdiction. I know that we all have a right for our judge, legal judge, but in my interpretation, this judge is judge who is very fast and who's very effective, and who use, for example, decide in a positive way, of course. Nevertheless, I'm trying to introduce two regulations. It's a European Small Claims Procedure and European Order for Payment Procedure. These two regulations have been adopted in 2006 and 2007, and still we have to think about one main feature of EU private international law, that that time the principal aim, the main argument for adopting these two regulations was targeted to simplify the recognition and enforcement of civil judgment. Why? Because that time we still have exequatur special proceedings in Brussels I regulation. This is the really old aim of the European Union, because in 1957, when the Rome Treaty has been adopted, we have, of course, a free movement of persons, goods, services, capital, but also in Article 220, we have also fifth free movement, and it was free movement of civil and arbitral awards judgments. Problem with arbitral award judgments has been resolved 6 months after Rome Treaty taken into force because of New York Convention. The aim for simplifying civil procedure was not the really proper aim, or what was not the specific aim of these two regulations. Of course, still there is just in preamble soft statement that these two regulations are intended to simplify and speed up litigation. What does it mean, simplify? Maybe we have to hate these two regulations, because these two regulations should take out work for address. These two regulations are written in the language of moderate consumer, of moderate person, individual, and the aim is to litigate if you have IQ 90 or 100, to be able to litigate cross-border cases without any legal aid, without any help from your barrister, etc. So it's a little bit not good postulate for us, but it's true that simplifying means to using standard forms which can be fulfilled by person itself and to be able to initiate proceedings without any legal help. I would like to just introduce two main features for both regulation. European small claims procedure and European payment order we can use only for pecuniary claims and only in a cross-border cases. I think it's adequate reader documents a little bit moved my table, but in principle we can use these regulations also in a legal relationship when, for example, American wants to sue person in Czech Republic before Slovak court. Definition of a cross-border case is a legal definition in both regulation, and the definition is that we can use this regulation. Cross-border case is introduced when just one of the party has another domicile or habitual resident as the court which will initiate the proceedings. So it means that two Czechs can start in litigation before Slovak courts. Only those three possibilities which are underlined are not sufficient for the definition of the cross-border case. So Slovak cannot sue Slovak before Slovak courts because both have the same domicile or both are from the same state as the court. And for example, American cannot sue Slovak before Slovak court because American is not another member state, and vice versa, Slovak cannot sue American before Slovak courts for the same reason. So we can use this regulation also against defendants from non-EU member state. That's possible. There's a little bit problem what to do if domicile of defendant is not known. My two comments are cross-border. If cross-border case is already set up, so it means that claimant has domicile from the different member state as the court. We can go further. The problem is because the cross-border definition, cross-border condition is already fulfilled. But what to do if a cross-border case is not already set up? It means claimant is outside the EU or in the same state as a court. In the first situation, we the court is obliged to deliver all documentation, also across the border, so it means Indiana EU member state, and of course outside the EU. But if cross-border case is not already, so it's according to the Czech preliminary ruling C 327, Udo Mike Linder. And then the second case, A against B, is a case from Austria. It's a little bit different, but it's outside the scope of our regulations, because this case means that we cannot introduce proceedings against person, against defendant whose domicile is not known. According to Udo Linder, it's okay. According to case A against B, it's not possible. The differences between two cases is obvious. First case is contractual obligation, and the second one is non-contractual obligation. First case means that you have a contract where you have address, for example. You have statement of your defendant where his or her domicile or habitual residence is supposed to be. And specifically, Court of Justice, and that's maybe important comments, Court of Justice has stated that if, for example, in the contract there is an obligation for both parties to inform other contracting party, when one party is moving to another member state or is changing the address, provide for the new address. It means that you can also, if you do not have the information where the person has been moved, it does not mean that you cannot initiate and you cannot litigate against such a person who breached his or her obligation. So the contractual obligation we can litigate also against a person, against the defendant whose domicile is not known. But with regard to non-contractual obligation, we cannot do so, according to this Court of Justice judgment. Don't be afraid, because non-contractual obligation to litigate non-contractual obligation under the European small claims procedure or European payment order is excluded. So we do not have to carry about it. One more point. This is the case from Slovakia. We have been very optimistic when these two regulations in Slovakia, has been adopted, because you can get a final judgment, execution title in Slovakia in regular, non-problematic civil dispute after 2-3 years. Comparing 2-3 months when final judgment should have been appeared according to European small claims procedure and European payment order, it's quite a big advantage, pushing us to use these two regulations. Therefore, we were thinking about to find some cross-border case in regular cases which have been for example, with regard to contractual obligation, it had been signed and concluded 10, 20 years ago. What to do? And we are trying to find this way, this path, which is introduced in this case, which is still pending before Court of Justice. According to Slovak Civil Procedure Code, we have also the status of intervener. Intervener could be, for example, a company which is dealing with debt recovery issues. And for example, this is the case when Slovak energetic company with thousands of contracts with thousands of consumers, and of course thousands of consumers who are not paying his or her debt. We have been introducing this institute, company from Czech Republic is intervener as a contractor with the Slovak energy company. They have a contract that this Czech company is responsible for recovering the debt of for the company, for the energy company, and of course this company has rights for some provision when recovery will be successful. Of course, first instance court is hesitating if such a maybe artificial cross-border case is sufficient for the definition and sufficient for the European small claims procedure. If we have to find some differences, European small claims procedure, you can sue maximum 5,000 euro. A European payment on the maximum value of a claim is not limited. The second difference is that European small claims procedure, you can introduce in various, and you can use various criteria for jurisdiction. The best way is, of course, prorogation, choice of court, but you can use all other possibilities according to Brussels 1 regulation, according to CMR, according to Montreal Convention. You can use any criteria for jurisdiction. So you can do forum shopping. In European payment order, there's one limitation with regard to consumer. You cannot sue consumer outside his or her country of his or her domicile or habitual residence. That's the only one limitation in contractual in European payment order with regard to consumer disputes. One maybe practical information. You are not obliged to, with regard to taking evidence, you are not obliged to attach all your supportive documentation, all your evidences, all your accountings. It's not a condition for proceedings. And for example, you are obliged just to make a description with a few words. And for example, this does not prevent the claimant for submitting where appropriate, when it's contesting, further evidence during the procedure, for example. This is useful when court should deliver documentation to the other EU member state, and the question of translation of this documentation is needed, for example. Both regulation, both procedural instruments can be used in any EU official languages. EU member states are obliged, for example, we can also say are obliged or they are pushing to use more than one language. For example, Czech Republic accept European payment order also in English and in German. Germany accept French, English, Italian. Member states are pushing to introduce only one court for the whole territory of the respective member state, dealing with all European payment orders, with all European small claims procedure. I think only Germany adopt this position. We have only one court in Germany dealing with all European payment orders for Germany. We have only one court in Germany. In Slovakia, I'm not happy to announce that we accept only Slovak language. Okay, and let's come to this final information. European payment order is a procedure for uncontested claims. It means you can get a final judgment, final order after more or less 60-70 days after claim has been introduced before court. European small claims procedure allows for member state to introduce limits for appeal. So far as I know, there are only 2 or 3 member states which adopt limitation for appeal. In the Slovak Republic, we do not have any limitation, so you can introduce appeal against the first instance judgment, which means that we are going to the second instance procedure, which is outside the scope of the regulation, which of course is good information for us. It's good news for us that in appeal procedure, when you want to litigate in our member state, I'm pretty sure that you need to find someone, lawyer from this another member state to help to this appeal procedure. And review of the judgment is in exceptional cases is the specific revision for those member states which limits the appeal. So it does not mean that that you have 2 chances or defendant has 2 chances or unsuccessful party has 2 chances, ordinary appeal and the specific revision according to the regulation. Now you can choose, member state can choose for an ordinary appeal or limit this, and then the party has the specific review, which is the ultima ratio, and the revision institute introduced solely under the regulation. Ladies and gentlemen, that's my few words and few information about this regulation. Thank you very much.
I'm about to exhibit my ignorance Yeah, but I don't mind doing that. I do that every day. But if, as you said, this is a procedure for uncontested claims, but then you mentioned that there is a right of appeal, it seems a little bit illogical. But if the claim is uncontested, why would someone then want to appeal something that was uncontested in the first place?
Let me clarify this. Uncontested claim is for European payment order. Yeah. So it means that if you reach European payment order, it means that your claim has been uncontested because defendant introduced any appeal. So it means that if you introduce European payment order and defendant will contest your claim, there are several possibilities how to get further. From that time, we are outside the scope of the European payment order, and we are going to the ordinary civil procedure, or we can skip to the European small claims procedure if the amount of the claim is not more than 5,000 euro. So it means uncontested in the sense of final judgment. Mm-hmm. If we have final judgment in European payment order, it means that the claim is uncontested. In European small claims procedure, the claim can be contested, but still we can have first instance positive decision.
Okay. Just out of curiosity, you mentioned case 627, which, if I remember correctly, it was asking whether an intervener should be treated as a party within the meaning of the ESCP procedure. I realise that no one really knows this, but what would be your guess and your suggestion for what would be the best answer?
I'm not objective because this is my contract and my case. So I would say,
I'm glad you declared your interest in the answer then. Okay.
So I would say yes, it is, but I'm okay with the position that this contract and this party is a little bit artificial, and the cross-border case is not really present in this case. Mm-hmm. We wanted to use this regulation for speeding up the proceedings. As for example, the company from the energy sector, they have 5,000-6,000 proceedings permanently, waiting 2-3 years for the final judgments, and those claims are from 50 euros to maximum maybe 2,000-3,000 euros. We wanted to use this regulation for speeding up the procedure, so that it is not forum shopping. We are claiming consumers in their state where they have their domicile, so we are not using forum shopping. We are just using the procedural vehicle for speeding up the proceedings. You have time limits in these proceedings, means that you can have a judgment also if the claim is contested. For example, defendant is contesting the claim. Yes, I have already paid, etc., etc. You can still have a final judgment, first instance judgment, in approximately 90 days, 3 months. And those time limits are not fixed. They are not. It is not jus cogens. But if the court would not respect these time limits, the possibility for recovery of damages is open. So they are under the pressure. I mean, the judge, the court is under the pressure to respect the time limits because of Frankovic doctrine, for example.
So if you said then, quite rightly, that a Slovak suing a Slovak in front of the Slovakian courts, this regulation would apply, then why hasn't the Slovakian parliament just said, if everyone likes it, the lawyers like it, the claimants like it, let's just take it, let's copy and paste it and call it a Slovakian statute, and take away the limitation that there needs to be a cross-border element. So we'll, from a legislative perspective, say we have exactly the same procedure in a non-trans-border case.
It's very logical.
I'm not running for any Slovakian political office, I should say,
and optimistic. It's not a problem for judges itself. I'm not going to contest why, and even if 2 or 3 years length of the civil proceedings is too much, or not comparing Italian civil proceedings or Spanish civil or even criminal proceedings. But it's the matter of the whole machinery. I mean, Slovak Parliament can introduce law which 5 or 2 days or 3 days limits for courts when the whole judiciary and the machinery is not ready for such overloading cases or for such an amount of cases. For example, we have courts, we have small courts in Slovakia with 3-4 judges, 2 or 3 judicial clerks, where monthly cases, loading or cases, is about 200-300 per month. So it means that
between three judges.
3 judges. So it means that every single, for example, every single judge should deliver 100 judgments per month. For example, yesterday I have been speaking with a friend of mine. He's judicial clerk at the district court. They have already tables, and according to one table, he's also dealing with civil cases. He's obliged to deliver 90 judgments per month.
And do they have to be reasoned, or can they just say, that one wins, that one doesn't, that one wins, that one doesn't? Do there have to be lengthy written explanations for why someone won?
The length of judgment is one part, and the real reasoning is the second part. We have tradition of long reasoning, repeating facts with very less argumentation, and that's our thinking, that if a judgment is 20 or 30 or 40 pages long, it's reasoned.
Okay.
But these, of course, these I mean, this copy paste system is of course present.
Okay. Well, okay, ladies and gentlemen, then thank you very much. Can I just say to both of our speakers, so Dr. Szilágyi as well as Dr.
Miroslav.
Miroslav, yeah, exactly. Ferenc and Miroslav, who say again, thank you very much for both. And we have goodies and nice things to eat and drink, I believe, at the Czech Bar Association. So thank you so much again for having allowed us to use this wonderful room and wonderful facilities. And now we'll go and find out what a Czech buffet looks like, which I'm very excited to do. So thank you very much, and please follow us as we go to the buffet.